floor is yours.
Great. Thank you, Senator. Good afternoon, and thank you for the invitation. My name is Michael Geist. I'm a law professor at the University of Ottawa, where I hold the Canada Research Chair in Internet and E-commerce Law, appear in a personal capacity representing only my own views. I've appeared before several parliamentary committees on AI policy in recent months, focusing on three priorities: privacy, copyright, and transparency. I touch on some of these in my opening remarks, but given the growing political momentum behind banning young Canadians from AI chatbots, alongside similar proposals for social media, I want to use my opening time to address that directly. The case for these bans is weak, the harms they would create are significant, and they should be rejected in favor of broad-based AI regulation. The concerns motivating these proposals are real, we just heard some. But the discussion conflates two different questions: how to regulate AI chatbots and whether to layer a kid-specific access ban on top. AI chatbots are not social media. The category itself is not well defined. The same underlying models are accessible not just through ChatGPT and Claude, but through APIs and AI features that are now standard in Google Search, Microsoft Office, and Apple operating systems. The definitions matter once you start getting into regulatory purposes. Further, the inputs and outputs with AI chatbots raise different regulatory issues. The input side, AI prompts, resemble search queries or private messages, not public posts. Treating prompts as something that companies must monitor and report on builds a system of corporate surveillance over interactions that I believe most users reasonably expect to be private. The AI responses, the output side, is where the focus should lie: accuracy, safety on topics like self-harm, and design choices that draw users into emotionally intense interactions. These are best addressed through regulations, not bans. Other jurisdictions have already chosen this path. For example, California rejected an age ban, but has passed legislation that requires disclosure, crisis response protocols, and restrictions on sexually explicit content for known minors. I've written about how a social media ban for kids raises a host of concerns, including the failure to address risks that affect all users, the privacy and surveillance risks of age verification, and thus far the demonstrated ineffectiveness of a ban. But a kid-specific AI chatbot ban would be worse than the social media version on virtually every relevant factor. Age verification extends a surveillance infrastructure across open-ended and growing set of services, effectively requiring all Canadians to verify themselves in a way that sacrifices privacy by sending their IDs to services that raise risks of security breaches and that may evade Canadian privacy law. Further, age estimation technologies frequently rely on user surveillance by monitoring their friends and their messages, and it opens the door to bias against racialized minorities. Don't take my word for it. Hundreds of scientific experts have said the same. Moreover, the costs of cutting off young Canadians off AI are concrete. The tools do have demonstrated educational, productivity, and accessibility benefits that don't compare to what we see on social media. Now, Canada should move forward with effective AI regulation. First, an AI Transparency Act, mandating the disclosure of corporate safety policies, training data inclusion, government and law enforcement demands, and the age-related restrictions that major commercial chatbots already apply. It shouldn't take the AI minister having to meet with executives to get this information. All Canadians should be able to see what is already happening before legislating around it. Secondly, a modernized privacy law that addresses both the inputs to AI systems and the outputs. Data sovereignty concerns are not solved by Canadian data centers. They're solved by Canadian privacy law that actually applies to Canadian data with real penalties. And we need privacy laws that directly address the risks posed by re-identifying de-identified data, a risk that is exacerbated by the power of AI inference and which was scarcely addressed by today's decision from the Privacy Commissioner involving OpenAI. Third, an enforceable duty to act responsibly that is tailored to the chatbot context. The architecture of chatbots, where output is generated in response to prompts rather than pushed through an algorithmic feed, makes age-tiered design feasible. A duty that mandates and audits developmentally appropriate design across different ages is a version of age-related regulation that fits the technology. A binary access cutoff borrowed from social media is not. Now, I recognize that the political appeal of bans is obvious, but the case for them, especially in AI, is weak. We need to move on the harder and more useful work of building an effective Canadian model for AI regulation. I look forward to your question.
Thank you, Dr. Geist.